The hearing of the Senate Judiciary Subcommittee on the Courts will come to order. I'm delighted to be getting this underway. We will begin with my opening remarks. Then I'll introduce our guest, Mr. Schrader, who is here from the Office of Legal Counsel. And then he will have a chance to make his prepared statement. And then we will go ahead with questions and answers. And we perhaps will have colleagues, I don't know how many, appearing virtually since the Senate is not presently in session and essentially every colleague is away. And if so, I will obviously interrupt to recognize colleagues who persist. But let me start by thanking Ranking Member Kennedy for agreeing to hold this hearing with the Senate out of session. He is busy on the ballot shortly in Louisiana, so he has important things to do down there, and I'm grateful that he has encouraged me to go forward notwithstanding, and we will continue working together in bipartisan fashion on these issues. I want to express my appreciation also to him and to his staff for the work that has gone into a bipartisan report from the subcommittee on executive privilege that this hearing and the previous hearing will help inform. So again, appreciation there. As I mentioned, this is our second hearing related to the oversight logjam between Congress and the executive branch. In recent years, it has become harder and harder to get meaningful answers from the executive branch. Last August, in the first hearing, we heard from experts about executive privilege problems driving this gridlock and how we can fix it. We found clear bipartisan agreement on a few points. First, since the dawn of the Republic, the executive and legislative branches have worked in good faith to negotiate solutions in oversight and information disputes. Executive compliance with this so-called accommodation process has been governed for years by a Reagan-era presidential memorandum. That memo set out a substantive standard that the executive should comply with congressional requests for information to the fullest extent, and that the president should assert executive privilege only in the most compelling circumstances. The memo also set out a process for making those executive privilege assertions. It assigns the Department of Justice, through the Office of Legal Counsel, the role, I would say, as an ombudsman, to balance meeting Congress's information needs to the fullest extent against the executive's interest in confidentiality in compelling circumstances. Both this balance and this process have completely broken down in recent years. Administrations of both parties have steadily expanded the scope of information withheld from Congress on executive privilege grounds and the circumstances under which the executive branch withholds it. Far from treating executive privilege as a last resort triggered by an assertion by the president himself, executive branch officials routinely withhold information without any formal assertion of privilege ever occurring. Compounding these problems is OLC's reliance on extreme separation of powers theories that bear on the executive privilege question. One example is absolute immunity, the notion that White House officials can ignore congressional subpoenas because they are absolutely immune from ever testifying before Congress. That theory has no support in judicial precedent. Indeed, it has been outright rejected by federal judges appointed by presidents of both parties, including now Supreme Court Justice Ketanji Brown Jackson as a district court judge. But it lives on in a parallel universe over at OLC, and a private one at that, as OLC opinions are often kept secret from Congress and the public. OLC does seem to disregard these determinations by Article III courts of what the law is. The second point of agreement we found was that Congress needs to step up. When the executive branch controls the information sought, the documents are in their care, and the doctrine applied through OLC opinions, and the process followed, Congress must look elsewhere than the executive for tools to overcome executive blockades. To restore the Reagan memo's balance and process, we will need to rethink how Congress can revitalize its role. The Office of Legal Counsel is the driving force in the executive branch on questions of executive privilege and separation of powers. That's why I'm pleased to have Assistant Attorney General Chris Schrader with us today. To my knowledge, Mr. Schrader is the first sitting Senate-confirmed head of OLC to appear before Congress since Jay Bybee testified 20 years ago. It's been a long break, Mr. Schrader. And the first sitting OLC official to appear since 2010. Getting this accomplished took 10 months of negotiations, and I want to say a word of applause to my staff for their persistence in this endeavor. But it was vital for us to understand OLC's perspective on executive privilege and the accommodation process, given its central role. So here's what we face. If the Office of Legal Counsel resumes the role of ombudsman, if the Office of Legal Counsel meets Congress's need for information to the fullest extent, if it limits executive privilege assertions to actual assertions in compelling circumstances, and if it restores the process of the Reagan memo, that creates a very different terrain than we now inhabit for Congress to navigate in undoing the information blockade. So we need to know which way OLC is going. Getting Assistant Attorney General Schrader here required a few accommodations from us. We agreed to focus on OLC's role in questions of executive privilege and separation of powers. We will not be discussing any matters related to ongoing litigation or January 6th or outstanding oversight requests to the Department of Justice outside of those to OLC itself, should they arise. We need to fix this mess, Mr. Schrader, and the baseline for that repair will be clarifying how the executive branch will respond to information requests from Congress. If it is to return to the Reagan memo, we must understand how and when that change will come, where we go when we feel we are being thwarted, and what assurances from the executive Congress can have any reliance on into the future. I look forward to you shining some light on these issues. Bitter experience has brought us to this day. Let us hope this hearing is a turning point. Thank you, sir, and you are recognized for your statement.